again, and to all of you. Can you hear me? Our webinar today is titled Occupational Safety and Health, an Informal Perspective. And it's an extremely topical issue with critical implications for India's vast informal sector workforce. I'm Divya Verma, and I'm co-founder and director Knowledge and Fair and Free Foundation. Before we delve into the topic itself, I would like to introduce the organizer this webinar. Aajeevika Bureau, as many of you might know, is based in the Western Migration Corridor of Rajasthan, Gujarat, and Maharashtra, and is a specialized public service initiative that works with a special focus on informal sector, seeking to ensure dignity, safety for them. Work Fair and Free Foundation is a new entity that has been carved out of Aajeevika Bureau that undertakes dedicated knowledge and policy work on the issues faced by migrant and informal workers. So occupational safety and health has been a key area for practice and inquiry for the teams at Aajeevika and Work Fair and Free for the past few years. The issue, as you all know, has of course gained a lot of prominence in the recent months on account of very dire, widely reported kind of accidents that have resulted in major casualties across prominent industrial clusters all across India, and especially in the summer months. Every day, for example, newspapers carry reports of dire kind of tragedies that we see in this sector. For example, if we talk about numbers a little bit, in March 2021, the Union Labour Ministry informed the Parliament that at least 6,500 workers lost their lives during the last 5 years while working at factories, ports, and construction sites. According to Geneva-based Industrial Global Union, about 162 workers died in commercial and industrial accidents in India in 2021, with an average of 7 accidents reported per month. As practitioners and researchers working on the ground, we know that these estimates might be severe sort of underreporting and underestimates actually on the issue. So our work on this issue has been really at the intersection of practice, organizing, and systematic research and inquiries. And we're really very excited to present our learnings with you today. My colleagues Maansi, Parpiani, Bhakti, Vardam, Kavya, Bharadkar, and Shubham, Kaushal will take us through the presentation, following which we will hear from our eminent panelists, Professor Padmini Swaminathan, Dr. Dheeraj Kumar Nite, and Mr. Suyoshi Kawakami, who have kindly consented to be on this panel today. A very warm welcome to the presenters and the panelists. We are really happy and honored to have you join us today. We will then open it up for questions and further discussions. To start things off, I invite Mr. Rajiv Khandelwal, co-founder and executive director, Aajeevika Bureau, to welcome the audience. Rajiv ji is a familiar face to many of you. In his leadership, Aajeevika Bureau has really earned national recognition for its contribution to the domain of informal work, labor migration, and urban inclusion. Over to you, Rajiv ji, for your welcome remarks.
Thank you, Divya, and congratulations. And this is, I think, one of the first offerings of the Work Fair and Free Foundation that we are out there, and we are also bringing out 2 very important sets of evidence, I would say, on the landscape of informal work and occupational safety. There are many familiar faces here and familiar names here, and most of you are already part of the labor movement and understand the conditions that we try to address through various interventions. And I have to say that despite years of struggles that workers have engaged in, I think the core issues around work and work conditions remain very, very vexed in our country. We still fight for minimum wages, and we represent some of the most dangerous kind of work sites anywhere in the world. Which is not just, data will continue to underreport accidents and deaths, but we know for sure, even just from experience, how hazardous our work sites are, and what is assumed as normal anywhere else in a more civilized kind of economy will be unacceptable by way of what our workers are exposed to or are forced to, or conditions in which they're forced to work. And it is very curious to me, why do we not do more on this front? Why is worker safety seen to be so marginal in the morality and imagination of our policy? Why is it seen as something that is not likely to change, except when when conditions of work become very formal, Now, that the formal end of the spectrum is a very small one, as you know, and even the formal one is becoming informalized slowly, which means that conditions in which workers will work, the safety conditions that they will have, will continuing to deteriorate. And that is that is the problem that we continue to address in our work on the ground, as well as in research and in kind of on policy kind of grounds. The two studies, Divya, I'm really glad that these are finally coming to a close. They will take us to Mumbai and will help us understand, what is going on in a situation where millions of workers have gathered in a small geography and are exposed to one of the most dangerous kind of locations, and in what kind of choices they are making here, and how do they accept and even normalize the conditions of danger in their work life. So I think understanding that would be very critical. And of course, Shubham and Kavya, I know, are going to walk us through the legal opportunities, the legal options that exist for workers to exercise to seek justice in the event of accidents and injuries. I think both of them are very relevant to the state of discussion today, and I'm very grateful to bring it together and welcome you and the entire team and all the panelists. I'm actually very excited to be listening to Dr. Dheeraj, Dr. Shiyoshi, and Dr. Padmini. I haven't heard enough of them, and I'm really keen to know what their views and perspectives are so that we can build on our own research and policy agenda as we go forward. So thank you for having me here, and I'll be quiet and just be a quiet listener. Thank you so much.
Thank you, Rajeevji, for your remarks. And yeah, we are also very excited to bring this first offering of Work Fair and Free as a new formal entity to your midst. I now invite Dr. Tara Nair, co-founder and director research at Work Fair and Free, to deliver her opening remarks. Dr. Tara is a prolific researcher with decades of work across various domains, including livelihoods and labor, rural finance, and gender. And very happy to have her also in our midst. Over to you, Tara ma'am, for your remarks.
Thanks so much, Divya. I think much has already been, said by Rajiv and Divya in terms of the work that we do and the concerns that we have for this particular topic, etc. But I must welcome you all once more on behalf of Work Fair and Free. As both of them said, this is the first outing in the world of, kind of displaying our whatever little scholarship that we have generated so far, and also we intend to kind of generate in future. I really do not want to spoil the suspense in store for you, what is our researchers are going to present. But I think if I have to reiterate what both Rajiv and Divya said, I think occupational safety and health has hardly been a matter of public discourse in India, and when something very dramatic happens, like a large industrial accident where a lot of kind of workers lose their lives, maybe the media attention would be on it for a while, but that attention generally wanes, as time passes. But this interesting studies, one set of the inquiries that we are going to present, are actually I want to give us a glimpse into the everydayness of, injury and accidents and injury, and the possibility of those injuries and accidents, and the personal experience of that, and as it happens in the smaller sort of, workplaces that we have, as which are informal in many ways and very unsafe, etc., etc. So, including construction. I think that's another sector that we need to talk about when you talk about injury and exposure to injury and injury risk. So these studies are going to, on the one hand, give us a kind of a very very sort of detailed glimpse into the experience of an injury and the consequences of it and the decisions which are taken on the basis of that. A very labor-centric kind of a research sort of a whatever kind of research approach. And on the other hand, it also will tell us what are the institutional arrangements available for us, which maybe we are not really leveraging for various reasons, for various kind of gaps and deficits and things like that. We perhaps could also discuss a little bit about, building or creating a culture of prevention. The first time maybe we really talked about, or we thought about the culture of prevention when actually COVID happened, because the COVID really affected all classes of people, not only workers. Maybe even there the workers were affected more proportionately, disproportionately more than other maybe blue collar workers and things like that. But we realize that prevention is an extremely important part of, in the cycle of kind of occupational safety, health thinking. So I think we are also perhaps giving a little sort of, insights into those concerns. Definitely these kind of, if you really sort of, put together these 4 presentations, we are highlighting the kind of misalignment that one sees in the arrangements which are constitutionally or otherwise provided to take care of some of these things, and the actual practice and actual following and things, but for various reasons, maybe, of course, the pervasive informality, the apathy of the state in terms of enforcement, several other reasons really play to kind of, create that kind of a break between what we think is there and what we are able to really deliver or give our workers. So maybe at the end of it, the discussion would be in terms of having some sort of an all-encompassing framework to look at the accidents, the occupational health and safety sphere, which is very complex and extremely. We're not talking about the same thing when we talk about health and safety, because health itself is a highly kind of layered sort of occupational health per se. That's another area that Aajeevika has done significant work on in terms of getting people together, workers together to kind of fight a very sort of what do you call it, a very determined fight against something called silicosis, for instance. Or the workers in power loom sector, power loom hubs that we work in, the kind of, the kind of hazards, health hazards they are subjected to on an everyday basis in the factory floors. So we have a lot to discuss. This is just the beginning, and I think it's a very good beginning because we are actually giving an extremely grounded sort of a kind of a look into a single geography, a very concentrated industrial hub, and a very concentrated experience of a very dense experience of pain, injury, and and loss of well-being. So with that, I'm extremely happy that Professor Parpiani has agreed to be a discussant, Professor Dheeraj Kumar, and of course, Mr. Trishul Kavakame has also agreed. We think we have a very, very interesting and extremely relevant panel. And I see there are large number of participants, so I think I really do not want to continue this. So I think I'll invite Divya to proceed with the rest of the day.
Thank you, Tara ma'am, for your remarks. I think very pertinent observations on the everydayness really of the risks and injuries in the informal sector and the culture of prevention or safety or the lack of it in this sector. I now invite my colleagues for the presentation. All of them have been engaged with Aajeevika Bureau and Work Fair and Free team over the past few years, based at various locations, including Mumbai, Ahmedabad, and Udaipur. Maansi, Kavya, and Shubham have moved on and are currently pursuing their higher studies in labor-related domains. Very happy to report that from universities abroad. Maansi is pursuing her postdoc with University of Copenhagen. Bhakti is still with us with the Work Fair and Free team in Mumbai. Kavya is pursuing her PhD at Bristol University, and Shubham is completing his master's degree at SOAS in London. So very happy to have you all back in our midst, and I now hand it over to you all for taking us through the presentation. So over to you, Maansi.
Thank you. Thank you, Divya, Rajeevji, and Tara ma'am. It's so nice to be here and present some of this work that I think in many ways has been some of the most challenging and at the same time meaningful work of my short professional career, working with Aajeevika, but specifically on OSH subjects. I'm really happy that we could get such esteemed discussants to talk about these complex subjects with us. And the research has not been easy, as I said. We deal with a very deep paradox that most of you all have already alluded to, that on the one hand, we know that occupational accidents and diseases are highly prevalent. They happen at an everyday basis. But on the other, we don't talk about it every day. It's restricted to the big, industrial explosion or big news story, fires. So we are constantly faced with that challenge in the field of how do we even start talking about risk and safety with workers when they have to work and live with it at an everyday level as part of their everyday work. So that's how we started this particular study. It was back in 2019 in an industrial neighborhood known for a range of small workshops producing metal, rubber, plastic products, kind of cheap manufacturing for low-end quality export or for the local market. And in 2019, we saw a discussion emerge around safety. This was in the backdrop of multiple fires that had happened in this particular neighborhood. And we wanted to seize that opportunity and know what people thought about safety and whose responsibility was to maintain safety in the workshop. How did workers see safety? How did they see injury? How did they see fires, illness, electrocution? There were so many things that were very visible, but very difficult to talk about, given the pervasive poor working conditions, poor wages that workers had to confront head on first before they could even think about safety. But using the opportunity of an interest in discussing about safety, we thought we would go to the workers themselves and get a sense of what they thought safety meant for them, and developed a research project which involved these different methods through which we could maybe construct a different language of workplace safety that would encompass the everydayness of injuries, body aches, chest issues, gastric issues that I'll go on to elaborate a little bit more on. So what emerged was a sense of normalization, that injury is normal, risk is normal, disease is normal, coughing is normal, tiredness is normal, fatigue is normal, hospitalization, going back home for periods of rest, all this was normal because the work was so difficult that there was no other way to do the work without falling sick regularly. Some of the issues that we recognize to be widely prevalent on the left, you can see is a power press machine. There were wide reports of hydraulic leakage, malfunction. As you can see, these are second-hand old machines. A nut would come loose and the press would fall on the worker's hand. So this was a particular machine that several workers reported having had big and small injuries from. The second was polishing work that you can see on the right, which led to metal dust particles flying, which workers had to protect themselves using ad hoc materials like a napkin or a piece of cloth. But there was no other way for them to work because it required them to hold the product pretty close to their face to be able to polish its different angles and shapes. So these are just two examples of everyday risk and injury that was pervasive through the workshops, because both of these functions, whether it's the power press that renders a metal block into a certain shape. So you can literally make anything on a power press machine by rendering a certain shape, or polishing, which is also a crucial element of all kind of metal products that we use in our everyday. And through these examples, workers kind of said how it was almost impossible to separate themselves from the work, and then the risk of injury and health issues that emanated from these work materials and machines. So that led us to directly engage with these materials and machines and ask workers to think with us, tell us how do they interact with these risky machines and materials, what are the techniques they may use to keep themselves safe, given that they need to do it every day. So from the normalization emerged this idea of what are the norms that workers use then to keep themselves safe. And we did a photo voice project, and here you see some of the submissions that workers made and some pictures that we took of small metal adjustments, trying to keep a distance, putting a block to ensure that the screw doesn't come loose. So really what Bhakti will also go on to talk a little bit about what is known as jugaad, right? Small adjustments to anticipate the risk from certain machines and materials, and then protect themselves in order to avoid interaction with these issues. So this was in 2019, and as we all know, 2020 and 2021 were the pandemic years, and somehow risk just assumed a different role in all our lives, and definitely in the workers' lives that we were doing these studies with. So we had to pause the study formally. Of course, we continued to engage with issues of loss of work, which was in this continuum of many risks that workers face: starvation, the journey back home. So the occupational health and safety study continued, but the one that we were focused on in terms of injury and health took a slight pause. When we resumed, it was from a different perspective, because over the 2 years of 2020 and 2021, we realized that it's probably not just machines and materials, but the entire work culture that had become so exposed during the pandemic years, the low wages, the lack of security in terms of being able to return to work after a brief time in the village, no social security benefits, and so on and so forth, that we started to then come back to the topic in a broader way by understanding risk and safety, but without centering the accident so much. Because of course, our focus had been on the accident. We've been working with the workers for compensation, trying to understand the conditions in which the accident happened, what kinds of proofs they had for their work during the time of the accident, but to try and broaden our understanding a little bit from the accident to the work culture in which accidents or injuries or health issues occur. In the interviews that we conducted in 2020, we tried to adopt this different approach, not centering the accident alone, and to understand how workers not only do jugaad to machines and materials, but in many ways also to their own body. So as much as the study is about injury, it's also about healing. We heard this statement many times, that to work in manufacturing today meant that you needed to have hands like cardboard. You cannot have frequent injuries, perforating your hands, because then you cannot continue working. And for the longest time, our perception of the hands like cardboard phrase was that you cannot get injured. But in the second phase of the study, we realized that it's not only about not being injured, but also about healing, and healing fast, and healing well, so that you can return to work. So normalization of injury was also happening in the context of normalization of healing. And that was a different perspective to occupational health and safety, because it clearly revealed one particular important facet about occupational health and safety, particularly for this workforce. And that was, to put it shortly, that the workers who had family, kinship, friends, some kind of support system in the city were able to develop these hands like cardboard, return to work, heal, take a break from work, so on and so forth. And those who did not have this kind of network, who were newer migrants, unfortunately often had to leave the city completely and could not become a part of this work culture that says that you will get injured and you will have to heal and you will have to come back. So far, our focus had been on senior workers and apprentices, which Bhakti will also talk a little bit about, because senior workers who had some experience of working have a sense of machine and materials. And that's definitely an important distinguishing point, that senior workers are definitely able to avoid and heal from injury in a better and faster way. But it was also true that for apprentices, it wasn't just that they were younger and didn't know the machine or the material, but also that they didn't have the network to take even those 2 weeks off without having to depend on the employer to sleep inside the premises. As many of you may already know, workers sleep inside the workshop. So if they're injured and not working, they need to rely on the employer's benevolence to even stay in the city. Otherwise, they need a friend or a family member or someone who would let them sleep and rest in their home or their workshop in the period that they are able to recover from whatever it is that their body has encountered. So just to put in a nutshell, that there is definitely the distinguishing factor of how much work experience you have with these machines and materials, but there's also the life history and the family background and the support system, the responsibilities. All workers have different remittance demands and pressures, and all those played a big role in terms of how workers saw injury and saw occupational health and safety overall. All this is important, and I will quickly wrap up so as to pass on the presentation to Bhakti. All this is really important because our entry point was a difficulty in making a case for compensation, for telling workers, this thing that has happened to you is not right, and someone needs to be accountable. You are not accountable for it. And that is so difficult to do when that thing that we are trying to exceptionalize happens every day and happens to everyone. Workers in many cases accepted that it was their fault. They were too tired. They had done 2 night shifts. Why were they working again? Even in the same breath, recognizing that this production pressure was a bit too much to handle for them. So this particular attempt to understand workers' differentiations of who is able to see injury as something moral, economic, socially wrong, for the lack of a better word, and it can be approached for compensation and paralegal support and legal aid, relies on, in many cases, on the number of years they've spent in the sector, as well as on if family to support that legal process that often, as we know, takes a long time, even though our attempt always is to focus on mediation. But I will not go into those details, just to introduce the context of our inquiry and to now focus a little bit on what happens when an injury occurs and the post-injury care that workers need, and then we'll move on to the legal aid and the compensation aspects of occupational health and safety. So over to you, Bhakti.
Thank you, Maansi. Am I audible? Yes. So Yeah. So basically, as Maansi was trying to establish the fact that skilled workers have some sort of experience in operating the machine over the period of time, they understand how to, over the period of time, they understand how to operate the machine as well as how to save themselves from that accidents to happen. Sometimes they come up with some jugards which saves them from the immediate accident and the cuts. And it also keeps the productivity of the work they are doing, because the entire market is actually functioning on how much productive these workers are, and they have tremendous pressure on them to be very productive when all the 12 to 13 hours they contribute to the work site. So skilled workers, but since the entire responsibility of that unit is kind of on the shoulder of the skilled worker, that's why they have some say on what they are ready to do and what they are not ready to do. So sometimes if the sensor is not working, if there is some a major problem in the press machine or something like that, then they at least have some liberty to say no to the work. But when it comes to unskilled worker who is kind of they do not have this confidence to take forward the work. Sometimes they are just given the understanding of how to put the job inside the machine and get take it out. That's all they know about machine operating and the work they are doing. So what happens in this kind of cases, since they don't have understanding of the machine and they don't really know if there is some problem in that, if the problem is very evident that machine is making noise or something, then they can spot the problem. Otherwise, they just continue to do the work the way they are asked to do. And when something goes wrong, they are not able to spot it. And when we interviewed them after the accident, they said that something went wrong. We didn't understand what it is, and punch fell on our hand. Even our responses, our reflex was not very sharp that we could pull off our hand very quickly so that we could save our fingers. So when it's not like we're trying to compare these skilled workers and unskilled workers, but there is also there is something which indicates that the experience of skilled workers are little different than unskilled worker, and these are the things which kind of differentiate the experiences. For unskilled worker, it comes as more as a shock, and they don't really understand what to do. But in both the cases, if they are working in this kind of informal units, they don't really have any first aid or any sort of medical thing in their within their unit. Mansi, you have stopped the screen sharing. Yeah. Of to go to the hospital. So far, the number of years since 2016, we have our center in the place where we have done this research. We haven't seen a single ambulance which comes to take the worker to the hospital when this kind of injuries takes place. So that is the level at which these injuries are treated on a everyday life of the worker. And when sometimes their employer take them to the hospital, most of the time they have to take the auto rickshaw and find the places where they can get admitted. And mostly their employers try to avoid going to the government hospital because it comes with the problems of, for them, it is a problematic thing to get the MLC, medical legal document cases. They have to register that. Mansi, I'm on the previous slide right now. And also they have to take care of this part. An employer also tries to ensure that there won't be any police complaint or any other department would get involved in this kind of accidents. And these accidents are very small that it is possible for them to hide from this kind of government institutes and other institutes which may come across and do some investigation. And as Maansi was trying to say that workers stay on their work site, that's the only place accommodation they have. after getting discharged from the hospital, it becomes very difficult for them to decide what to do, whether to go back to the same employer in the same unit and try to be the smallest help which they can do, and hope that employer will take care of the bandage and dressing, which are the expensive part of having that injury and healing process. So sometimes they go back to their unit and they hope for these things to get done. If not, then they go back to their hometown. We have heard some of the cases where employer just offered them 20 to 25,000 rupees, gave them a bottle of coconut oil and asked them to go back to their hometown. It is taken as casually as that, and compensation, the legal compensation is officially absolutely denied. And in order to get these kind of medical treatments, none of the units in this kind of informal manufacturing unit areas, they are not covered under ESIC or WC. So there is no formal sort of insurances they are part of, these workers are entitled with. And that's why they can't really go to the hospital to get this kind of services. Maansi, next slide. So yeah, so there are some short-term impacts which is seen on the bodies of the worker, but in the long run, if they have to get then the physiotherapy or they have to get the artificial hand, there was one case where one worker lost all four his fingers, and employer was saying that if he continues to work in my unit, I will help you to get the artificial hand. Apparently, none of that happened, but even to get those things, having those options open is also not a facility for the workers, since there is no formal sort of registration they have as a worker working in this kind of manufacturing units, as well as there is no other insurances they are part of. And also to get the basic documents like getting the disability certificate and everything is a struggle for them. Why? Simply because when they are admitted to the private hospital, employers, most of the time employer take care of those expenses and they keep all the bills and everything with them. None of these documents are accessible to the worker. There was one instance when we were interviewing one worker, and he said that he was just 19 to 20-year-old person. After the lockdown, because of distress in the hometown, he came to the city, and after started working in that plastic manufacturing molding unit, he met with an accident. And when he was recovering from that accident, employer asked him to stay at his place so that he will not go to any police station or any labor lawyer or labor court to get the compensation or anything. And those documents were locked in the cupboard of the employer. So when we were helping that worker to understand the case and explaining the procedure of getting the compensation, that worker literally had to steal his own medical papers from the house of the employer and get the pictures of it, because he was very mindful, if I'll take them away from here, they will get to know. So he had to take it to the person he knows, and they click the pictures, and then pictures were sent to us, and we were able to understand what the exact situation is. So workers do not even have that much right on their own papers. So in all these situations, worker kind of deal with this situation, and they don't really get paid for the day they meet with an injury. After that, there is no proper formal payment from the employer to take care of the daily dietary expenses and requirements, as well as the other medical related expenses which are there. And if the worker decided not to go back and file the compensation case, and even if that person manages to get some of the paper by doing some of the jugaad, then also it is very difficult procedure. They go to really available for them, then there is so much of low happening about that. But even if they do, the process is very tricky, and they don't have any place to stay and process this, and so they either there itself. if at all they try to get some compensation through the help of some private lawyer or something, they charge them a lot. If a worker is meeting with an accident and the body loss is around 10 to 15%, then for him, that entire hand, if he loses one finger or two fingers of his right hand, which is functional hand, for that worker, it's that entire hand is dysfunctional and he cannot really operate as a worker in any kind of unit. But in medical sciences, that loss of a body part is just to 10 to 15%, and compensation is calculated based on that. So that amount itself is very small. And in that, if they are asked to give 10 to 15% to the private lawyer, they are not really left with anything in their hand. And most of the time, if they are not employable, some of them try to go back to the workplaces where they can get the job. But if they lose the actual finger, which are used for the work of their right hand, functional hand, then they find it difficult to get the job. And the amount which they receive at the end of this compensation and everything is very small for them to restart their life. So things are very complicated and difficult for them to even to think about the compensation, and even after getting the compensation. I will pause here in question and answer. If there are any questions, then I'll definitely take up and share more details of these case studies which we have received in during this research. Thank you. Over to you, Kavya.
Thank you, Bhakti. I hope I'm audible.
Yes, you are.
Sure. I'll just begin introducing our research while Maansi brings the slides up. This was a very interesting piece of research for both Shubham and I to do, and for Maansi to do, because it's located in a very, very interesting and curious space that not a lot of people have had the chance to explore so closely before. It's not the kind of thing that that I have been able to read anywhere else. We weren't able to find a lot of extensive or comprehensive studies on the subject either when we were doing literature review for this. And that entry point that we're getting into it is just trying to understand where law meets social reality. That's how our own inquiry into this research is situated. So you see now how the 4 labor codes have been enacted, have not yet been implemented. So this paper is in that sense located in an area of legal confusion, legal paralysis. And there have been a lot of diverse and complex changes to this legal position, but when it comes to employment injury and compensation, that area remains largely unchanged. One conceptual issue that comes up with that space is, of course, like a lot of people before us have also noted, that there is most laws for workers' rights are based on an imagination of the formal workforce, where there is one fixed employer, one fixed workplace, there is an employment contract, there is an ability to access state institutions such as hospitals, courts. Bhakti spoke about this at some length, and Shubham will also later. And we find that when it comes to informal work, which is maybe 92% of the Indian workforce, you find that those contexts are very different, and all of these legal assumptions get disrupted severely when you consider how informal workers work, how they experience accidents at their workplace, how they experience the process after the accident. And going to court would then require translating those social realities to a more limited language and imagination of law. It was very interesting to try to understand how that could happen, especially because unlike a lot of other labor laws, the Employees Compensation Act does not intrinsically limit itself to formal or informal workers or workplaces. It's in that sense very accessible by definition to the workers that it covers. But despite that, and some of our findings are in the slides ahead, but just one thing that really stood out to us during the course of this research was trying to understand the role that paralegals play in helping workers to access the law, in making these formal laws and formal legal institutions more accessible to informal workers. Bhakti used a beautiful word for it, jugaad, and we think that that is very true. Most formal I mean, most lawyers, most labor lawyers or lawyers in civil law would not even think of adopting the strategies that paralegal workers adopt when they're trying to collect evidence on behalf of workers or trying to help workers draft their claims, accompany workers to spaces that they might not be as comfortable going on their own. That being said, what we're also understanding about employment compensation is that this still remains a study that is situated in the corrective rather than the preventive space when it comes to occupational injury, because the law is such and its implementation is such that it is much cheaper to let accidents happen than to prevent them, which then leads to the subsidization of more productivity, unsafe machinery at the workplace through occupational risk that is cast upon workers. Could slide, please. So like I was saying, the research gap that we identified was that literature on occupational health has a very myopic focus on organized work, on the organized sector. It does not seem to capture how these situations play out in the informal sector. So it was, in that sense, fairly exploratory research. We were very fortunate to be located within an organization that did exactly that kind of work, which is the lead cell in Aajeevika Bureau. And just being associated with the lead cell was very useful in documenting what is a very highly invisible process. We were very fortunate in that sense to also rely on many years and decades of praxis of our colleagues in the lead cell, some of whom are lawyers, some of whom are paralegal workers and volunteers, some of whom counsel workers. So the study was conducted through case studies, interviews, and focus group discussions with these legal activists, and with a little bit of participant and non-participant observation at the sites where conversations around employment injuries happen, as well as textual analysis of the Employees' Compensation Act. Slide, please. Some of you might already be aware of Aajeevika Bureau's work, but just to give you a picture of what kind of workplaces the workers who come to lead after employment injuries are engaged in. Both Gujarat and Rajasthan have slightly different industrial contexts. In Rajasthan, you have more agro-based, mining-based construction work, stone carving sort of work. That is the work that is most accessible to informal workers. Whereas in Gujarat, like Tara ma'am was saying earlier, construction is a major sector that employs migrant workers, but you also have small and larger factories. You have different industrial contexts in that sense. Some of them are located inside the city, some of them are clusters, some of them are peri-urban. But what is common across them is the domination of these 3D jobs, dangerous, dirty, and undignified jobs by migrant workers in highly precarious and informally mediated employment relationships. Slide, please. Once we began to study this, we were able to understand from our colleagues how after an accident occurs and workers are seeking compensation, there's a fair amount of diversity of what paths that they can do that through. So the most common, of course, is compensation through formal agreement or a formal agreement with the employer. But you can also access compensation by going to the Labor Department for a claim for compensation through litigation. Some employment injuries, especially when they are of an environmental nature or a massive chemical hazard, fire hazard, tend to also be compensated by the state. We also came across, of course, there isn't much time to delve into that now, but a very distinctive category of a very distinctive pathway for compensation, which is the Matana Pratha and social negotiation of employment compensation after usually fatal injuries to workers. Slide, please. The law itself, like I was saying earlier, is quite exceptional because for starters, it works on the legal assumption that an employment injury is the fault of the employer. The worker is not required to prove that the accident happened because of the employer. There is already the assumption that the burden of proof then lies on the employer to prove that they were not at fault. And in doing that, that makes the system of seeking compensation much more accessible both to formal and informal workers. The law intends to incentivize employers to adopt better OSH practices, but like we were discussing earlier, that does not tend to always be the case, and therefore you have the subsidization of poor OSH practices or poor safety conditions at work through additional employment injury risk to be faced by workers. There are other ways in which the law is very accessible to workers, such as when it comes to jurisdiction, it's open to the worker to claim compensation either where the injury happened or the district where the worker resides. In that sense, migrant workers are not inherently excluded from this law. There is a lot there. There are opportunities for the inclusion of migrant and informal workers in the law. But how these situations play out in reality is what leads us to having a lot of reservations about their ability to access compensation through the law and access the same quantum of compensation that they are entitled to under law. As Bhakti was saying earlier, compensation in the law is imagined in a more narrow way. There are a lot of invisible costs that the law does not really imagine, such as the food that a worker will have to eat to recover from injuries, or the cost that is cast upon their families to take care of them when they are recovering from these injuries. The law does, however, include the cost of treatment of the worker. And if the worker loses the ability to work partially or fully, then it also includes compensation for making sure that the household is able to subsist. Slide, please. Just a broad summary view of what our thinking on the law is now before I hand over to Shubham. One overwhelming conclusion was that the law assumes a very cut and dry employment relationship. And many of our colleagues have demonstrated in different ways to us how that assumption is very, very flawed. Either that employment relationship is not that cut and dry because there are many layers of subcontractors. The worker might not be necessarily aware of who the employer is or not be able to access them. Or there may be creative legal strategies employed by the employer to prevent such liability from being cast upon them. The law also assumes that there is documentary evidence and that police and hospitals will behave in a certain rational manner. But in speaking to our colleagues, we found out that that both hospitals and police have their own agents and stakeholders who behave in a more unpredictable manner than the law would let you believe. And I think Shubham might be able to discuss this in a little more detail. So it is in this inconsistency between the legal assumptions and the lived reality that Lead's work is located in helping informal workers access compensation, and which is also why there is this tremendous compensation, tremendous contribution in terms of creativity by legal activists and lawyers to gather and generate evidence from scraps of data. It almost crosses into investigative journalism sometimes, the way that our colleagues narrate how they're able to help workers to find attendance diaries, use SMS, or go to the work site and take pictures without being observed by other people, or use GPS to be able to hunt down the address of the workplace. I'll hand over to Shubham.
Thank you, Kavya. Next slide, please. So to get more specific about what Kavya was mentioning in terms of the creativity in the practices that Lead brings in. So just before that, I'll give a brief overview of the four major trends that we observed in compensation seeking behaviors among migrant workers. So we have to understand that the lifespan of migrant workers is very short. When they start working, they may be of the age of 14 or 15, but by the time they retire from the workplace, it is as early as by 35 to 40 years of age. mostly resulting from accumulation of long-term body burdens of doing arduous jobs and working in hazardous conditions. But these long-term health impacts never give rise to any sort of claims. Health impacts begin to arise when symptoms of occupational diseases become visible in a mass number of workers in, say, a specific area, and which also involves intervention by a trade union or a civil society organization. Whereas in case of minor injuries, these are often ignored by employers as well as workers, since this risk assumption is seen as part of the job, unless it results in temporary, partial, or complete disablement, and in which case the compensation is limited to the employer bearing medical treatment expenses, but the worker still loses wages for those days lost. In case of accidents resulting in deaths, employers are quick to extend ex gratia sums to the relatives and elders who often arrive at the workplace from the source villages. This practice, which Kavya was earlier mentioning, called Mautana Pratha, gets somewhat replicated at the work destination. It's a practice that is seen to be more prevalent among Bhil and Garasia tribal communities present in Western India. Village elders and community members mobilize at the workplace and insist on immediate payment of ex gratia sums by the employer. In this case, the Panch, one of the heads of the Gram Panchayat of that particular village, holds more weight over immediate dependents and family members in deciding how that compensation sum that is received would be apportioned. Next slide, please. So in this context, how the kind of challenges that the worker faces in accessing compensation, one can think about how the dynamic nature of work of daily wages and informal labor conditions create challenges in establishing employment relationships. So for instance, construction workers identify workplaces by the name of the construction company at the site or the contractor that might have hired them to do the job. So this reveals nothing about the nature of the work that is being done by them, the name of the principal employer, or the exact address of the construction company. This makes serving legal notice of the accident challenging and also can indefinitely prolong the claim seeking process. Next slide, please. So what we observed in the lawyers' practices in Aajeevika Bureau's lead cell is that they do not view the modalities that earlier Kavya was referring to as mutually exclusive. Instead, what they seek to do is to foreground a strategy that would be suitable to that injured worker's particular circumstances. They look at how this law can be used to strengthen their claims. Some of the specific challenges they pointed out also include experiencing prolonged hearings due to very high volume of cases before the Labor Commissioner. To overcome some of these challenges, the lawyers emphasize on quick response to the complaints and evidence gathering, since claims can also be very time sensitive. For instance, service of notice of the accident at the workplace and lodging of FIR, recording injuries to create evidence of the occupational injury and the causal link, insistence on visiting government hospital that is perceived as more credible in generating more credible evidence and causal link with the occupation. So next slide, please. So to refer to a particular case study to probably clarify this further. So I'll mention a case study of a daily wage construction worker from Aswara district in Rajasthan. They had applied for compensation based on a claim arising out of partial disablement due to electrocution at a construction site in Surat in Gujarat. This case illustrates the challenges. in mounting credible evidence. So the case primarily relied, it was a successful case, and it primarily relied on 3 documents. With one was a diary entry at a local police station in Surat where the accident took place. One is, the second is a discharge certificate of the hospital where the worker was given treatment, and a disability certificate from the district hospital in Baswara. So the first 2 of these were obtained through an RTI application done by the Surat team of Aajeevika Bureau. Now, what is interesting to note is that the admissibility of the police station diary was seen as sufficient proof of occupational injury. Lodging of an FIR or police inquiry under Section 174 of CRPC are rare in case of injuries. So the experiences of other lead lawyers also shows that even where police entries, such as in this particular case, is taken, crucial information such as the description of the accident resulting in the disabling injury could be missing. That makes it very difficult to establish the causal link between the injury and the employment. So just to conclude here, I think what really our study is also trying to say is that the Employment Compensation Act is a beneficial piece of legislation in that it provides absolute liability to the employer, but still it is blind to the invisible economies of care. It does not address the power and informational asymmetry in the employer-employee relationship. The onus of collecting evidence and initiating the process also rests on the injured worker, wherein we see in this case that a civil society organization like Aajeevika Bureau is stepping in to respond to the imbalance in this relationship. And it is also trying to demonstrate the potential of what higher uptake of employee compensation can be as a pathway to better protect informal and migrant workers, particularly in a labor regime that is not merely about weak enforcement of labor market regulations or labor protections, but an intentional labor governance that is about weakening and withdrawing these protections in the name of labor market flexibility. Thank you. Over to you, Divya.
Thank you, Shubham. And thank you, Maansi, Bhakti, Kavya, and Shubham for taking us through these presentations. I think really relevant insights from the ground on how workers actually perceive, risks and injuries, how these are pervasively normalized, and also how presence of local social networks, skill levels, and experience really determine some of these recovery processes that workers have to endure. Of course, challenges abound in accessing legal and emergency medical response, and legal frameworks themselves, as Kavya mentioned, are myopic in nature, posing challenges at every stage in accessing compensation. There's also a lot of dissonance between legal provisions and the realities of an informal sector workplace. Finally, I think the studies also highlighted some of the creative strategies used by lawyers and paralegals on the ground in helping workers actually access some of these claims. So thank you again for these 2 presentations. I now invite our panelists to share their perspectives on the presentation and their remarks more broadly on the issue of occupational safety and health in the country today, especially as it pertains to the informal sector, which of course forms the vast majority of workforce in India. First, we have with us Professor Padmini Swaminathan, who's an eminent feminist economist. She has held various positions, such as the chairperson of the Center for Livelihoods at Tata Institute for Social Sciences, Hyderabad. And she's also served as the director of the Madras Institute of Development Studies. She's a widely published scholar in areas such as industrial organization, labor, education, and health. Welcome, Professor Padmini. Very happy to have you here with us, and I invite you to deliver your remarks.
Thank you. Am I audible?
Yes, yes.
Yeah. Okay. Let me start by thanking the organizers for inviting me. And I also want to say that it was very poignant reading both the papers that were sent to me for, so I was able to go through both the papers that were presented here just now. and reading them was very poignant. I've done quite a bit of work on occupational health, but not so much on injuries. So this was quite an eye-opener for me when I read these particular papers. If there are questions on occupational health, I'll come back to it, but I think I should talk about the papers that have been presented and the work that is being done by the organization here. I'm reading both the papers together because one of them deals a lot with the everydayness of the injuries that have been happening, and the other one is more on the legal part of it that could be this thing. So I found that putting them together and reading them together raises some very pertinent questions that we could undertake or we could ask ourselves. Now, I'm just going to also point out certain statements that were made in these papers to also get a clarification from the authors. In the first paper by Maansi and Bhakti, that was The Hands Like Cardboard, there's also a line which says, those working in illegal jobs. What do you mean by that? How can somebody be working in illegal jobs? They're working in jobs. So what do you mean by when you say those working in illegal jobs? So I was quite intrigued by that statement. I work in a job that is not recognized, that is not formally recognized, and so on and so forth. But if it is illegal, what am I trying to do there? So there is a line in your statement there about the legislation not applying to these people and to also those working in illegal jobs. What I found very interesting is the kind of negotiations that happens with the employer. In used unit, the majority, the injury happens. So there you develop different norms of healing. So these are very interesting things that I learned from this particular paper. There's a very important statement also made there in the paper, and that is workshops were registered as retail shops and not as industrial enterprises or factories. So I found that very interesting. And the reason why I'm raising is that when you're trying to marry the legislation, Compensation Act, to the kind of injuries that are happening, you need to also to state those 4 or 15 people that you have been interviewing. Are they working in these retail shops, in the units that are registered as retail shops, or as anything else? Because that is a very legal this thing, meaning. So if I'm working in a retail shop, what does it mean? I'm not working, but I am doing factory work. So you are now saying that these shops, these are registered as retail shops and not as industrial enterprises or factories. And hence, does the Workmen's Compensation Act or the Employees Compensation Act apply to retail shops? I think that would be very interesting, because you are collecting information, and if these are registered in those manner, how would you then try and work out this particular phenomenon of employees' compensation? Does it apply to them? The second thing that I found very, which I wanted you also to reflect a bit more is, all the time you're talking about migrant workers. Most of them, the ones that you have covered are you saying are from UP. Now, I'm also interested in knowing, are the migrant workers pitted against local workers? Because wherever I have done field work, or wherever I have examined the theses that I've done in industrial clusters, there have always been a kind of antagonism that has been deliberately built, including by trade unions, between locals and between migrants. So for example, a thesis that I examined of Durgapur industrial area, now the local workers are employed by the trade union belonging to the party that is in power, and they are pitted against the Bihari migrants who come in. So the ones who are employed by the unions which belong to the ruling party, now they get fair amount, of compensation and legislation, all of that applies to them, but some things do not apply to the migrant workers. Now you are here all the time talking about these are migrant workers from UP, and I'm interested in knowing, is the injury across locals as well as the migrant workers, or when the injury happens to local workers, they get a better treatment than what the migrant workers get? So I think that would also be interesting to find out. I was also very interested in the way in which you need to, you've complicated the whole thing by saying that most of the time, the compensation that is being given to people takes a humanitarian route and not the legal route. Right. So I think what you need to also say, if the legal route had to be taken, then what would be the nature? You could make an estimate of what would be the compensation that would be required. If it is not the humanitarian route, but if it had to be in the legal route, then what is the nature of, what would be the kind of compensation that you are talking about that the worker should be getting based on your reading and your understanding of the Compensation Act that you are actually talking about. Yeah. One of the aspects that I thought, if it is possible for you to explore, which is a very different angle, because you're talking about also having to deal with, in your Compensation Act, you also spoke about that the bills from the hospital make a difference. Now, I'm also thinking about, because in all my occupational health issues studies that I have done, I found that there is a complicity. The health personnel, the doctors in the area are in the employ of the employers. They do not work for the workers. And therefore, what they do is that they may not certify it as, in the way it needs to be certified, or they may simply not do the work that is required to be done. So my whole question to you would be that when you're talking, how do you build a bridge with medical person? And there you may need to take the route that feminists have taken when they've been working with cases of rape and domestic violence. Because what the feminists have done is set up units in public hospitals where, because when a person is either, rape or particularly domestic violence, now the kind of injury the domestic violence causes, the woman may not, does not generally say that she's been hit by her husband or a mother-in-law or father-in-law, whoever it is, whatever it is. But the doctors can find out from the injury, what is the nature of the injury, and they know that it is not because she fell down from the stairs or hit herself somewhere or whatever it is. The doctors know very well that this is not caused by that. The nature of the injury is very different. They are able to do. And they send them to the local council or to the NGO organization so that the woman talks to them and then comes out which says how that injury actually happened. My point that I'm trying to say is that, can you build up, since you're working on the ground, can you build some bridges with the medical doctors there to actually find out, even if the employer does not, if the employee goes there for certain kind of treatment, can from the nature of the injury find out that, and certify what is the seriousness of the injury that the person has actually got. So that is one area that could be actually explored. The other thing is between the paper and the kind of case studies that you've done. For the case studies that you have done, what would be, because you've already listed what are the non-negotiable or the minimum paperwork that is required if that employee's Compensation Act has to be employed to those particular, to the workers that you have actually studied on the ground. What would be these non-negotiable set of papers that you require so that the workers that you have covered in the first part of your paper, what is the nature of compensation that they can get? And in that, what I found very interesting is that the definition of the worker. You're talking about informal workers who may not be registered as workers at all. Now, is there any register that is maintained at the units that you have studied or whatever it is to be able to say that these workers were employed there? So what do you have to prove that these workers were employed there? Is there any proof that you have that this worker was an employee of that? Because the first thing that they will try and say, this is not my worker. And that has been the experience of BD workers in our country, because the BD is a home-based work. There is a very interesting, there's a very, the BD Workers Act it's actually very, very good act. But because by the time the BD Workers Act came into being, the organization of work changed from a factory into a home-based production. Much of that could not be applied to the BD workers. But the very interesting point that the judge in the Madras High Court pointed out was when the employer said that so-and-so is not my worker, So the judge said that where is your register? Bring your register and show me who are the people who are. And the employer did not have a register, and the workers were able to get their compensation or maternity benefit, whatever act that they had to get. So just find out where are these registered anywhere to be able to say that these people have been working there. And the very interesting, I'm sure, because you already have lawyers in your among your thing. But I remember listening to a whole talk at a labor conference by Kamala Shankar, who gave a very interesting, complete this thing about how the definition of worker keeps on changing in all our acts. And because because at every level different acts apply. For conditions of work, some apply, some acts apply. To be recognized as a worker, some other act applies. To get maternity benefit, you need to have a particular thing. So how this definition of worker keeps changing and what implications it has for the workers that you are actually talking about. Are they even recognized as workers because you're dealing with these informal people? Yeah. What I also found very interesting in your this thing is that several forms of women's work is invisible in the legal imagination of employment. So you may have studied the men workers here in this particular case who've been injured working with lathes and things like that. But have you come across any women workers who have been working here and who've been injured or whatever it is? So I'm also very curious, because here you're talking about domestic work, casual sanitation work, and home-based work. So all of these people are not there in the employee, the Compensation Act at all. So that itself also, I found very interesting that this is not there. But in your own, groundwork, did you come across women workers who may have been injured and who did not get any compensation or just got it on humanitarian grounds? Sorry. Yeah. I also, the other thing that you have pointed out very interestingly is that if you have to take the legal route, an important aspect of this entire legal route is that it has to be any kind of agreement between the employer and the employee or the worker has to be documented or recorded before the Labor Commissioner. And I found that very interesting because in all the cases that I also, the Second National Commission on Labor and many other of these official documents, I've actually pointed out how the appointment of some of these officials are key to get our act functioning. So even to certify what this factory is, to certify a worker, to get this thing, you may have to have the labor commissioner, you may have to get the safety inspector, you may have to get all of these officials. So who are these key officials? What you have mentioned is that for that compensation to be paid, if it has to be on legal and not simply on humanitarian ground, it has to be done before a labor commissioner. So are there sufficient labor commissioners who have been appointed? Because what we have been pointing out has been that the government of the country, both the center and the states, have not been appointing a large number of these. Many of these are actually vacant. And when we don't have these kinds of people who have been appointed, we may not be able to fulfill some of these conditions. So I'll stop there. And I think if you have anything else to ask on occupational health, I'll come back to it. So these are what I had to say on. I actually learned a lot from your papers, and thank you for having invited me. Thank you very much.
Thank you, Professor Padmini. Really useful comments on the paper. I think especially, remarkable point on the parallels between, women who endure sexual and domestic violence and how we can build bridges with the medical professionals to help ease some of the trauma that injured workers go through, especially post the accident. We'll come back to the presenters for their responses once we have heard from all the panelists. So now moving on, we also have with us Dr. Dheeraj Kumar Nitte, who's currently affiliated with the Ambedkar University, Delhi, as an assistant professor at the School of Liberal Studies. He's also senior research associate at the University of Johannesburg. Dr. Neeta is a social scientist with a specialization in historical anthropology, memory studies, historical economics, and labor history. And he's done extensive research on the experiences of mining people in India and South Africa in the 20th century, especially on issues of occupational disease and compensation laws in coal fields in India. So he brings with him very relevant experience to comment on the two papers that was presented today here. We are very happy to have you with us today, Dr. Neeta, and over to you for your remarks. Warm welcome. Maybe you could log out and come back in. And meanwhile, we can maybe hear from Mr. Kawakami and then get you back in the panel after as the third panelist. So yeah, we are honored to also have with us today Mr. Tsuyoshi Kawakami, who's Senior Specialist in Occupational Safety and Health at the ILO's office in New Delhi. He also looks after the Labor Inspection Unit in the ILO Decent Work Technical Support Team in New Delhi. He provides technical advisory services to strengthen national occupational safety and health policies and programs, and promote participatory action-oriented training for improving OSH in small enterprises and informal economy workplaces in about 7 countries across South Asia. So welcome again, Dr. Kawakami, and over to you for your remarks.
Okay, thank you, Dr. Divya Verma, and all the distinguished speakers. Yes, I'm very much happy to be here today. So let me share my presentation files, and then I'd like to use my PowerPoint. What up? Okay. Now you see now?
Yes, we can see. Maybe you can put them on slideshow.
Yes, I did. Actually, I did.
Okay, yeah.
Yeah, it's okay.
Yeah.
I think something a little bit wrong, but it's okay. Yeah. Okay. So, I have heard a lot about, compensation, or how can I say, how to help victims, etc. But the ILO activities today, I'd like to focus on more on prevention side. How to extend safety health, OSH means occupational safety services, to small enterprises and informal economy workplaces. You may have seen this, statistic. These are from ILO estimate. I think in many countries in South Asia, as you see, many workers are actually in the informal employment. More than 80%. Some countries like including India, Nepal, Bangladesh, particularly female workers, more than 90%. So this is really the major issue. Majority of workers are actually in the informal, employment. And then ILO, we have been, yes, ILO, we have been carrying out, many projects focusing on safety and health and other working conditions areas in informal economic workplaces, India and the neighboring countries. Our targets are, for example, small textile factories, many home-based workers, or waste recycling workers, including e-waste, electronic waste, small construction site workers, stone processing, or stone quarries, or agriculture, including tea plantations. Let me show you some example. Usually we do this, we have many participatory training methodologies and programs to, promote workers' own voices and ideas for improving safety and health and preventing injuries and diseases. So this is the pilot activity in Moradabad in UP, India. We had a home-based worker project. So in this regard, first, we can really invite home-based workers or informal economy workers to apply, we call it action checklist. Then they can walking around in the workplace. Okay, this is part of action checklist. This one we show, for example, material storage handling, clear and marked transport ways. Do you propose action? No, yes. And then we associate, good practice pictures so that workers can easily understand what it means. Then they can compare to their workplaces and check. This checklist covers around 30 items. So, starting with materials handling or workstations, and of course, chemical handling, machine safety, electrical safety, or basic welfare facilities like toilets and then, drinking water facilities, etc. So you see, this picture shows the workers are now checking their own workplaces. Then after coming back to, the workshop place, we can always show good practices. Because by showing good practices, workers can get ideas how to improve, also employers together. Then we invite them for group discussions. Then they can identify their proposals. Then after that, also we can train many, how can I say, trainers. And then they can train many home-based workers. Because I know we cannot train all workers, so that's why we can train many local trainers, representative workers, employers, or sometimes NGOs, etc. So after the training, we can organize kind of follow-up activities and the visit. Usually we can find some improvements, these are the small textile factory in Nepal, they cleared the passageway like this. And also they put labels to chemical bottles, to avoid, poisoning. And she's a home worker, she's using chemicals, she put labels because maybe some children or others, they may misunderstand this as just juice or water. And so they put a label and keep it in a safe place. This is a small factory in Chennai. Many workers used to work on the floor, but after the training, everybody has now workstation, chairs and desks. This one also, they identify, this is very dangerous, so they improve the electrical safety. So this is clear, many workers working in front of the machine without, the cover. So they put the covers like this. So here I'd like to emphasize all these improvements, ideas came from workers and employers by themselves, not from me, not from specialists, not from labor inspectors. Then they made improvements by themselves using their own resources. I know we provided just training, but they found, workers and employers, they found, this is dangerous, we better improve. They discussed and made improvements. So that's why we call this participatory approach. So for sustainability continuation, certainly we're very much promoting the establishment of workplace safety and health committees for continuous improvements. Again, this is a small enterprise in Chennai case, workers, employers, every month they discuss safety and health issues, and they can walk around and check their safety conditions. If they find any dangers or risks, they can discuss and start with improvements. So we are applying the same methodologies to many other workplaces. This is an example in e-waste recycling factory in UP. E-waste means electronic waste, like smartphones, or PCs, or laptops. So workers again walking around their workplace and with a checklist. Then they're also learning from the good practices. They always invite workers and employers to discuss together for solutions. Then workers' representatives, they are proposing improvements. So this is again action checklist designed for e-waste workplace, clear passageway, use push cart for carrying heavy materials, etc., etc. So we always again emphasize, please learn from good practices, before talking about points to be improved. So I think this factory already has using push cart to carry heavy materials. At least some units they have clear passageway and a good lighting system, and they have drinking water facilities. But also workers identify there are many points to be improved. So for example, if you look at this, many things on the floor, this can really cause workers and having the falling down accidents. Also many things on the workstation that can have injuries quickly. Sorry, this photograph is upset, but many workers still working on the floor, particularly women workers. This is dangerous. You see that there is a hole, from the storage area on the second floor. Maybe workers could fall down. So they identified these points to be improved. Then they started the improvements. Workers, employers, they discussed. So through the safety and health committee discussions. So the better lighting or better ventilation, clear workstations. Also again, better ventilation. Then, sorry, I think, yeah. This is before, you remember, so there are so many things on the floor, but after the workers, employers discussions, there's now no more, materials on the floor. This one, they used to use this kind of things for the chairs. This is not stable and may have falling down accidents. So at least now they have better chairs with appropriate height. They also added, hand grips for easier carrying. And also they, again, employers agreed to make a fence. You remember the second floor storage area, someone might fall down. So they put a fence like this. So I think from this experience, there are many other examples like this. I think this intervention by using participatory approach, starting with simple good practices, I think we can really convince both workers and employers. And actually workers, they have a lot of ideas because they're working there. If they're trained by this way, they can propose many necessary improvements to prevent accidents in advance. So then also this small factory had a small safety and health committee. So they are really agreed to work together. Because when we talk to employers, we very much emphasize safety and health improvements can really improve efficiency and productivity. We found many employers also, they are afraid of accidents or fires because they will lose everything. So we can tell them, you can improve, prevent fire, accidents, and diseases, injuries by using practical, simple methods. Then your business will be also successful. So by this way, I think many employers also, they do buy in our ideas. So we are now extending this approach, for example, waste collectors or recycling workers in Ahmedabad, working together with women's cooperative, this work, waste segregation area. So they are applying checklists, invite both employers, workers, to discuss improvements, and also train local trainers. So this one, I think trade unions, they are organizing a lot of cascading training to spread the training. This is our work in Pakistan. Also we are training to sanitation workers and the sewage cleaning workers. I think the same situation is happening in India. I know many sewage cleaning workers, without any protection, they have to work under the manhole, and then very, very dangerous. And a lot of news, I don't know, came in. Some of them were killed because of gas or because of falling down. So trade unions, they propose improvements, and we trained them. So now they understand all the safety risks. But actually I'm going to Pakistan again next week, and this time we are going to discuss with the government because they are employers. They are responsible for providing necessary facilities and the structure. We can apply the same approach to the training site, a construction site, particularly small one. This is they work with the Kerala government. In New Delhi, I can see also many workers working like this, working at height without any safety belt. So we also developed action checklist for construction site. Then we call it this WISCON training program. We also applied in Nepal. There are many small construction workers. I think strategy are informal economy workers, no compensation, no support. So they walked around in their workplace and applied a checklist and identified the points to be improved. And then negotiated with employers. Also, employers agree to provide at least some, basic helmets or safer shoes. And also, employers agreed to provide a toilet on the site because I know many women workers, they needed it. And also, we trained, worker and employer representative as a basic cost trainers. Now she started training their workers, on site. So this kind of on-site training is also very, very important. Okay, so we very much emphasize workers' voices and human-centered approach. Workers are often the first persons to notice OSH risks at the workplace. Workers have plenty of ideas to improve OSH risks, prevent accident injuries. So we should promote workers' participation and the training. That is also good for employers. So how to reach those informal economy workplaces? I think you know better than I, but in Nairobi, we work together with trade unions, NGOs, employers, government, because they have their own, access. For example, trade unionists, I found many of them try to unionize informal economy workers, so they know how to approach the informal economy. Employers, there were, trade associations, they buy products from such home-based workplaces, informal economy workplaces. So they have also access. So NGOs, I think cooperatives, also there are many excellent cooperatives working for, small informal economy workplaces. So by working together with them, we can really approach to informal economy workplaces systematically and increase our coverage. So our conclusion, extending occupational health support to small enterprises and informal economy workplaces. So cooperate with workers, employers, and also NGO networks. We should be very much human workplace oriented. So we should visit real workplaces and also collect local good practices to convince, particularly employers, also workers, to make changes. Number 3, organize participatory training workshops. Use easy to use training tools such as action checklist. Number 4, start with simple low-cost improvements. Sometimes there is misunderstanding. The safety health is very expensive, very difficult. Some improvements need more money, but there are, I think many accidents can be prevented by using simple low-cost methodologies. Then number 5, makes the training easy to participate for workers and conduct the training in their workplaces if possible. Because as you know, workers difficult to come to the training, if we organize it in the meeting room. If trainers like us, if we visit them, organize training just for 1 or 2 hours, many people can participate easily. So this is our experience. Okay, thank you very much.
Thank you, Mr. Kawakami. Yeah, I think very useful demonstration of the the best practices that are being implemented with the technical support of the ILO in various domains of informal work, cutting across waste collection, construction, small manufacturing, garments. And also very relevant to the kind of risks that we were talking about through our papers and our presentations earlier, and some of the context that Aajeevika Bureau currently works in. And of course, the importance of having ground up and participatory solutions, having worker voices in the design of some of these safety solutions cannot be overemphasized. So thank you for your remarks. We now go to Dr. Neete again. Sir, over to you.
Sorry, good afternoon, everyone. And I benefited a lot from listening to all two papers presented by a couple of friends. And also what Dr. Padmini commented on, it's a comprehensive comment that she shared with us. And finally, our friend from ILO on promoting accident prevention mechanism and minimizing the work hazards. So I wish to actually contextualize the discussion in some larger framework in which this issue emerged over the last now 100 years, because today we are in 2023 and it's exactly 100 years that Workmen's Compensation Act in India completed. So in a way, it's a centenary year of Workmen's Compensation Act. I hope we recognize the importance, and this is at some place we have recognized that it was one of the earliest social security, or at that time it was known as social insurance measures, one of the first social insurance acts that the government of India during colonial time had adopted with respect to the working population. And its importance as one of the major social security legislations continue to hold even now. What has complicated is that what we are set to discuss here, that this is the act, as one of the friends, Bhakti, rightly said, is not in itself discriminatory towards the informal sector labor. It covers all working population. However, there are conflict between the all-encompassing coverage of the act as a major social security act in India on one side, and the legislative loopholes that comes into play when the person at the receiving end, the working person at the receiving end, aims to receive redressal of their compensation claim under this act. So that is what I am going to highlight, and how the mechanism could be worked on to address the problem of power and information asymmetry, which was recognized by the Act. I will lay down here that the very Act recognized the problem of power and information asymmetry. And that's why, in fact, after 10, 12 years of a struggle, compensation commissioner post was created. That is what I have observed through the historical evolution of this Act, that the compensation commissioner post was created almost after a decade of the Act, precisely to address the power and information asymmetry that confronted the proper implementation of the Act, and to enable the victim to receive restitution measure available under this Act. So what we see that we do have a Social Security Act, but we do have two other conflicting circumstances which fails the necessary benefit that the working population should be able to secure from this act. So one of them is what many of our friends through those two papers try to show, that when we see the informal sector labor, which is of course over 90% of the total workforce, but here we are talking about the manufacturing and industrial urban workforce, which is where close to 50% of them are in the informal sector, because our agriculture, which constitutes the largest working population, is fully informal, almost fully informal. But within the urban industrial establishment, close to half of them are within the informal segment. And the fact that the informal workers often don't get labor contract for their employment, that becomes the biggest inhibition, the biggest hurdle to make necessary claim to compensation, to file the legal suit against the employer to seek their compensation, because they can't prove that are they employees of certain employer. In fact, through some studies, we know that one of the biggest advantages of those who are covered by Employees State Insurance Act, which covers only a small percentage even within the formal sector, because the coverage area of employees state insurance assumes that there should be minimum 49 or 50% working person employed by the establishment. But if we talk to the working person covered by Employee State Insurance Act, they report to us that the biggest thing that they achieve is the ESI card. ESI card, which confirms that they are employed by someone, and there is a document to prove this in the corridor of power, in the court, labor court, in other judicial redressal machinery. And that is the document which is missing in case of those who are not covered by the ESI kind of mechanism, which is not covered by the any kind of evidentiary document which either formal or informal establishments may have to provide to their working persons. So this, through reading of these two papers and the general experience of confronting this challenge, what we observe that this absence of an evidentiary proof to confirm that someone is employed by someone, that is the employment contract paper, becomes a major instrument that possibly we need to work on, and assume that one lesson that we can draw, that how we can generate the campaign, awareness campaign, to secure employment contract in even informal sector as much as possible, keeping in mind, keeping in perspective that that document is an instrument of taking up several social security benefits, if at all we intend to fight for that. The second lesson that I see from these discussions, and again other general experience of dealing with the issue, is that we are not just faced with a situation where the informal sector working person is struggling to secure their entitlement under the Workmen's Compensation Act, or nowadays known as Employee Compensation Act, but also the fact that we need to have a accident control mechanism as a movement which is absolutely weak in our country. In fact, from the 1920s onwards, when the Compensation Act began to be adopted by several countries, we saw historically that the safety first movement also started around that time. And the safety first movement was a matter of interest for the capitalist, because through the investment in accident control mechanism, they could have reduced the cost of compensation to be paid as a result of accident. But unfortunately, in India, the safety first movement, the accident control mechanism requirement could not emerge as an emphasized industrial activity, as an emphasized trade union activity. In fact, our trade union movement remained preoccupied with the demand for compensation, definitely in the formal sector, but accident control emphasis as part of the safety first movement remained de-emphasized in our industrial and urban struggle. As a result, what we see in these two discussions, that we do have vitiating work environment, either because of the low wages, because of the long hours of work, where the working person is absolutely tired, and all these are tolerated because there is absence of accident prevention sensibility. There is an absence of the motive of preventing accidents from taking at the first place. And that's one that we need to possibly take up. And I think Aajeevika Bureau may take this as part of their campaign, that how to promote two things together. One, the ability of workers to seek compensation, and at the same time to look forward and create a work environment when accident prevention mechanism should be also sought for. Third, as I said, that the act presumed power and information asymmetry, and therefore recognized the necessity at some point of time to appoint compensation commissioner, who was supposed to be a benevolent and welfareist official, the state official, and should be on side of the employer. However, we have seen that over the time, the experiences shows that they were often colluding with the employers to either the neglect their responsibility, or to be under pressure of the employer against the interest of the working person. And therefore, the legislative implementation of this act presumed also the important role to be played by the trade union movement. Now, what Aajeevika Bureau is rightly doing is basically filling the void where ideally trade union movement should have been taking up the issues of the organizing of labor and fighting for the proper implementation of the act. So to address the problem of power and information asymmetry, we need alternative agency. And I'm glad that Aajeevika Bureau is performing that significant role of necessary agency to address the gap in this system. But the very act had assumed that there would be a requirement of such an agency. Now we need to therefore take this responsibility, as Aajeevika Bureau is doing, as lead is legal education and ed cell is doing, that how we can strengthen the capacity to build this agency, where, as Dr. Padmini said, the sympathetic doctors, publicly conscientized doctors or lawyers or social workers are motivated to take up these issues and ensure that the working persons could have the enabling hands available to seek their entitlement under Employees Compensation Act, to seek how to deal with this power and information asymmetry. So that is another lesson that we draw from these two papers of strengthening this agency through involvement of publicly conscious, sympathetic doctors, lawyers, social workers. The last point that I wish to flag here, again, that becomes discernible from these two discussions, and which have a significant lesson for us, that this interface between the protective labor legislations, and here the case is of Employee Compensation Act on one side, and the subcontractualized, contractualized, informalized labor and working population whose presence is day by day growing in the neoliberal India, in the contemporary political economic environment that our country and the world in general have. Now, possibly we may have to imagine our legislation and our welfare programs, our social movement in a manner where we are not just we are meeting a new challenge, a new circumstance, where possibly the formalization of workforce, formalization of employment in the old way may not be the easy way out. And because now the Social Security Code is actually raising the bar for becoming formal too high. And in fact, that is pushing more and more working population outside of the fold of the formal. So possibly now we have a challenge to imagine the world of labor and their welfare requirement in a new way, where the informal is becoming the hard fact, and how then in the context of this harsh reality of informal labor, what legislative changes we can seek, what changes in the labor inspection machinery put in place by the state we can seek to address the growing horizon of the harsh reality of the informal labor. That's another thing that we may have to take up as a challenge, as a task, where the demand for formalization is not imminent solution. Instead, possibly we may have to imagine that how to rework the existing legislations and the existing labor machineries to secure the implementation of those legislations, which is in tandem with the growing informalization that we do have in our country in particular and the world in general. Because even the advanced European, Northwestern European countries are increasingly becoming informalized. So our challenge is a big challenge, but there we also see the same tendency happening. So these are the lessons that I see emerging from these discussions, and simultaneously we do have certain significant tasks ahead. I am glad that as I come to know about Aajeevika Bureau, contributing to fill the void, present an alternative agency, and possibly in light of these discussions, we may work out the way ahead to strengthen this capacity. So thank you very much for involving this discussion. It's advantageous for me and enables me to take forward some insight that we have gathered here and apply the takeaway from this discussion to my institutional academic environment as well. Thank you very much.
Thank you, Dr. Nite, for really tracing the history and evolution of the Employee Compensation Act at the outset, and very useful observations for on the importance of the work of labor rights organizations like ours, especially in this context where trade unions have really vacated the space of organizing and have left a big void. And you right that some of these legal frameworks actually assume that such institutional platforms are available for ensuring bargaining power of workers, but in the informal sector context, we see that some of these institutions are sorely missing. Thank you again for your remarks. I would like to hand it actually back to the presenters now to respond to some of the questions posed by the panelists. May I request that each of you take maybe 1 or 2 minutes to respond to the most relevant questions, please?
Yeah, I think Kavya will go first. Yeah.
Thanks, Maansi. There was one very interesting question that Dr. Padmini asked, and we should have thought of also including this in the presentation on the difference in scale between humanitarian compensation and legal compensation. I can't generalize for all cases, but I can think of 2 specific case studies where, both in Surat, where the compensation that was offered through compromise for humanitarian reasons was around 1 lakh, 1.5 lakh. And if you calculated using the legal formula for compensation, the due amount would be between 8 to 12 lakhs for that worker, because both of those were young workers. So it's quite disadvantageous for workers to receive compensation through informal means. And the only reason families go for it is either because they are unaware or underconfident in the legal mechanism for seeking it, but also because after a worker is injured or dies, the family has immediate need of money, which is where this informal bargaining for compensation is more attractive, because you don't know how long it is going to take to resolve a legal case. Another question that Dr. Padmini also raised was about what kind of documents are usually brought up as employment records. And that was very interesting for us to explore as well with the legal activists and paralegals that work with LEAD. A very diverse set of documents, in fact. Sometimes it's just an SMS from the employer saying, come to this place by this time. Sometimes it's a voucher that the worker has picked up at some point, some receipt of payment. Sometimes some employers might generally pay in cash, but might occasionally pay into the worker's bank account. In that sense, any scrap of evidence that is able to prove that employment relationship is generally quite useful in putting together enough evidence that the relationship exists. I'll hand over to my other speakers.
Bhakti, do you want to?
So, to answer to the question on particularly on the medical papers and all the other documents which are collated on that end, so I would like to draw some attention to the part where how these informal units are laid out in that area. There are so many small dispensaries which are available in that area. So when we visited those dispensaries and interviewed those doctors, they said that up to 10 to 15 stitches basic treatment is given inside the dispensary over there, and there is no record which they keep of that. Beyond that, if there is a major crush injury and the doctors, the local dispensary doctor are not able to handle those things, then they are taken to the hospitals, and there are few private hospitals nearby. So one of the worker who was admitted to get the stitches when he lost all 4 of his fingers, he was admitted in the nursing hospital, where all the other were the women who are kind of there for delivery, and this fellow was there to get the stitches done. And on the top of that, when I tried to talk to his doctor to ask, give us some basic certificate which says that this person received a treatment from you and for so and so reason, because employer took away all the documents. And there was in private hospital, there is no scope of filing RTI and asking for document or anything of that sort. Since the doctor was Maharashtrian Marathi and I I can speak Marathi. I was trying to convince him literally in my mother tongue to give some paper. He's like, I cannot do that. So I know why his hands were tied up. He must have charged for not speaking anything or something like that. But there are these consequences which we face in the larger discourse. And there were some few fire accidents which took place in the area where we have our field office, and those workers, there were around 9 to 10 workers, they were taken to the government hospital, and yet the record they have that they are unknown bodies which are found in this kind of factories. So it was even more difficult for us to establish the fact that they are these workers, because they stay on their work site. If anything goes wrong, all the belongings they have, they go disappear. They are disappeared from that place, and in the hometown they barely have the understanding where do they work and where do they have this kind of workplaces. So establishing these links is very difficult, and as I was presenting in that slides as well, that the employer, to hide the evidences of work or anything, they just keep changing their workplaces and other things. So it becomes very difficult to go back to these things. And even the hospitals and all the medical services which are available in the vicinity of that area, they are very much pro employer sort of organization. So it's a difficult task. We still try to navigate some ways to get the compensation, but yeah, it is difficult to establish the fact. Over to you, Shubham.
Thanks. Thank you for all of the really wonderful and insightful comments that you all have brought in. I think I was quite intrigued by the role of labor commissioners and compensation commissioners that was kind of highlighted in the discussion. So I think even during our case studies and a discussion with the paralegals, we found like how the absence of labor commissioners, the fact that there is so much understaffing means that they have to they might have charge of multiple labor governance, so they have to also keep geographically relocating to address the demands in various districts. So how that slows down the process, and given that compensation is such a time sensitive and a swift requirement for workers, labor commissioners and compensation commissioners play a very important role in implementing labor protections itself. I think but also I think the swiftness, the fact that there is such a need for swift compensation among migrant workers that we see is also because we have to understand that the wages that they get from their employers are or the design of the current employment relations is such that there's a abstinence from employers of even their daily social reproductive needs. Even for this, they have to negotiate with their workers to to be able to get the wages itself. So forget about familial or intergenerational needs being met. And this is not just enabled by the kind of organization of production that we have today, but also the labor governance, the imagination of labor laws also plays a very important role in this, because labor laws are not essentially designed with migrant workers' specific social reproductive needs in mind. As we see in terms of, when they migrate beyond interstate borders, they lose access to citizenship rights. They do not have housing. They do not have access to what other urban citizens might have. So it really poses a challenge in terms of this distinction between urban and rural of labor governance that that we are alluding to here. Yeah, thank you. Over to you, Maansi.
Yeah, thanks everyone. I need to kind of say that we really appreciate the time that everyone has taken, not only to read but also reflect and make comments and share your experiences. I think it has been really enriching for us, and there's been so much said and so many new ideas. So I think we'll also need to sit down again and work on kind of incorporating these comments in the revisions, but also in our praxis. Just to cover one or two points, I think it's very good to go back to the beginnings in many ways. Many of the commentators spoke about that. How does the practice of a workplace get formed? Through the history of the Employee Compensation Act, to the registration of the unit, as Professor Swaminathan said, right? A lot of the challenges emerge from the fact that there is this loophole that you can register a workshop as a Shops and Establishment Act. In some cases, deliberately done, in some cases due to the lack of Factories Act license being easily available. But a lot of those issues do arise from the way in which the enterprise is set up and the labor legislation is set up, and to look at that in conjunction with each other before we start arriving at the moment of the accident and what happens after, at the point of the accident or after. So I think it's been really useful, several of the comments, to reframe and also maybe clarify our writing when we write about what is seen as illegal, what was removed from legislation over a period of time and became a kind of informal and illegal, right? That is not in itself outside the legislative framework, but over a period of time and actions and certain policies has become so. And then to also, of course, respond to what praxis can do for this. The urgent need for employment contracts. We hear NACA workers insisting in our field experience of having some kind of paperwork. It can be something very rudimentary, but needing to know the address of the construction site, the name of the contractor. So you can see that many workers groups are beginning to recognize, just as we are, that we always come back to that documentary proof. And lastly, I think it was also very inspiring to address the successes, the wins, the approaches that other movements have adopted. The feminist movement for building a bridge with doctors, for example, was really inspiring. The ESIC movement that has been able to get insurance coverage to so many workers. So we don't also operate in a vacuum, right? That this is a marginalized group. There's been different kinds of marginalization, and praxis has addressed those vulnerabilities before. So it also gives us hope that we can also find maybe some pathways to address these misalignments, as many of the discussants put it. So thank you again for the time you've taken. We really appreciate it.
Thank you, Maansi. I just want to pause for a second to see if there are any questions from the audience, because we're already about 15 minutes past time. I can't see any in the chat box, but I just want to thank you all for this, very insightful discussion, and all of you, especially the panelists and the presenters, for joining. I think the presentations and discussions really gave us a clear sense of, how the intersection of various realities like fragmented production processes, pressures, and informality intersect with each other to produce conditions of precarity and hazards for millions of informal sector workers. And my whole takeaway, I think, is that the need of the hour is to imagine really creative solutions and pathways that can strengthen the agency of the workers and enable their demand making for a more robust sort of safety architecture, especially in a scenario where legal frameworks and implementation regulation on the ground is so patchy. So once again, many thanks to all of you. A big thanks to the audience for joining. A lot of people stayed through the entire duration of 2 hours, so special thanks for that. So we hope to stay in touch with all of you to take this important agenda forward. And please follow our website and social media handles for updates on our work and our publications. Wish you all a great evening.
Divyaji, there is Mr. Das wants to ask one question.
Okay, sorry. Okay, sure, Professor Das, please go ahead.
I'm sorry to cut into the time because it actually really went on for a long time. It's a very extremely interesting presentation. So I just was wondering, like, there are two small points I want to make. One is like in terms of future work, like if you sort of create some kind of typologies with reference to the workers and their link to the labor agency, and also in sort of 2 or 3 kinds of work arrangements, like the kind of work arrangement you have seen, let's say in Bombay. I mean, that's one part of what you may call as absolutely informal settings, but then there are several similar sort of settings elsewhere, like particularly within the GBNs, for instance, like the global production networks, like people who are working for global companies, but they are also working in informal environments. So what I'm trying to ask is that whether there are sort of like very nuanced differences in terms of how they address this question of, let's say, occupational health and injury. So if you can sort of see, maybe we can sort of see what kind of role the state and the other sort of formal or informal labor agencies are playing in addressing this. That is one part. The second very small point, sorry to take your time, is whether we have any like a global comparative view. Because in this, what happens, we are too sort of like engrossed in the nitty-gritties of a small place, which is really mind-boggling. But at the same time, if we suppose we would take a case of Bangladesh, for instance, the garment workers, for that matter, or a variety of similarly placed informal workspaces where injuries do take place, and how they have addressed either through policy or through certain interventions by the labor agencies. So what I'm saying is that strengthen or that will sharpen your arguments, and not to really spend too much of time on whether a certain policy instrument has worked or not worked. So that's all I would say. Thank you very much.
Thank you, Professor Das. I think Mr. Ajit Kumar also had a question, and we can close after that. Mr. Ajit Kumar, are you there? Maansi, do you want to quickly respond to Professor Das's comment?
Yeah, I can do that. And I can also respond to the other question by Mr. Kumar. I think they're both very interesting points. And in the written paper, we do address the global production networks and those kinds of workshops and the OSH concerns there, because of course, there are some instruments in place in the GPN kind of workshops that you might even have a doctor on site. You might have CSR policies for safety. You might have a fire exit and several kind of minimums for safety. But at least the research so far has shown that it has focused a lot on the safety of the workplace because of the fires and collapses than on the safety of the worker. So the focus has been on building checks and work environment rather than the process itself of work in terms of production pressure, time, and the way that a worker's body might be impacted by the working setting. So that's not our primary research, but we definitely locate our primary research in that work on GPN workshops in Sri Lanka and Bangladesh that have shown that the presence of a medical doctor on site also sometimes is not enough, because the medical doctor might be, talking on behalf of the employer, and often workers have to really make a case.
But actually, I'm referring to the tier 2, tier 3 firms within GPNs, which are like the informal workspaces that you're talking about.
Exactly. Yeah. So I think those would be, as you said, very similar to the workshops that we see in Mumbai. So definitely it would make sense to locate our findings beyond this industrial cluster and say that they can be found in a range of, as you said, also working arrangements, but also in a global perspective where one hears of migrant workers from South Asia working in Leicester in UK in similar garment workshops. So it's also no longer an Indian reality, as several of the discussants also said. So I don't want to take too much time, but the point is well taken to contextualize our study beyond our geographical setting. And the second question about occupational and non-occupational diseases, that's not something that we worked on ourselves, and I'm sure that there are other experts on diseases, but I guess my assumption would be that these are complex differentiations, particularly when workers sleep and live on work site. So at least in the context of our field sites, what is occupational hazard and what is just life hazard becomes a bit difficult to delineate, and therefore the need to have to take into consideration so many different aspects of work, and not just the work cycle or workplace or work product or machine. So, but it's a good provocation to have in terms of thinking.
Thank you, Maansi, and thank you, Professor Das and Mr. Ajit Kumar for your questions. So I think there are some inquiries on how the presentations and the video can be accessed. So we will put them up on the recording of the webinar itself will be put up on our YouTube channels, and we'll disseminate them further through our social media handles. And once the papers are published, we'll also upload them on our website. So I hope you will all stay in touch and be part of this important agenda that we hope to carry forward. Thank you again. Thank you, everyone, panelists, participants, and the audience for joining and for this insightful discussion. Have a great evening.
Thank you.
Thank you.
Thank you.